Alright, so let's talk a bit about how contracts are formed under the UCC. Alright, and so as we go through what the UCC requires, I will briefly step back into 2080 and talk about what common law requires just for comparison purposes. Because what we're doing is we're building on an established understanding of contract law. Alright, so really very similar to common law, at least in theory, is that it doesn't take a lot to form a contract. Alright, essential is an offer and acceptance are largely unchanged, except for the things that we'll address over the next few moments. Contractual intent, all right, that's the biggest thing, and to completely form a contract, the only essential element is quantity. How much of something do we agree to buy and sell? Or does buyer agree to buy and seller agree to sell? And really that's only the essential element. So courts are allowed to gap fill terms that the buyer and seller didn't agree to. Alright? So what does that mean? So buyer and seller agree to sell, 5 bushels of apples. Alright? Or 10 laptops. It doesn't matter as long as it's a good. But they don't agree on a price. Alright? Well, they end up in court. And the court is going to gap fill a price. And the way that they will do that, the way that the court, the judge or jury, depending upon whether it's a jury trial, would determine a price, is they're going to look at a reasonable price. What was reasonable in a commercial transaction for these goods at that time. Alright, so you'll look to similar transactions, you'll determine what the market value of the goods was at the time of the contract. Alright. Open payment. Well, there are default payment provisions. If payment is not discussed, it's a cash transaction. And payment is due when the goods are tendered at the same time. Right? Delivery. If not discussed by the buyer and the seller, there is no delivery. The buyer has to show up at the seller's place of business and pick up the goods. If the seller doesn't have a place of business, the seller's residence. Alright, or in cases of a warehouse receipt or bill of lading, goods that are housed off-site, and if both the buyer and the seller know that, then the buyer shows up at where the goods are located. Right? So we're not imposing a duty on sellers to deliver goods if there's no negotiated delivery term. Alright, let's talk a little bit about quantity. Alright, it can be a specific number, 5 laptops, 10 bushels of corn. The UCC also allows for output contracts. So if I have a peach orchard and a wholesaler says, we'll buy all the peaches you can grow in the next year, that's an output contract, and that will suffice for the quantity. All right. The opposite of an outputs is a requirements contract. All right. And the requirements contract is kind of the reverse, right? If I'm running a restaurant and I contract with a local cattle farmer, and I contract for as much cattle as I shall require, well, that will satisfy the quantity term, and really what it entails, both the output and requirements contract, entails exclusivity. So if I sign an output contract, I agree to sell all of my output to a certain buyer. If I sign a requirements contract, I agree to source all of my requirements from a certain seller. Right? So exclusivity is built into the output and the requirement contracts. All right. Let's talk about the merchant's firm offer. One of these rules that applies only to merchants, not to consumers, under the UCC. If I'm a merchant and I am selling cars, because cars would fit as a good, even though they're titled property, they are a good, and I say, you can buy my F-150, and I say it in writing. I give you an offer to buy my F-150 for $20,000 in writing. It's irrevocable, and it doesn't matter that you haven't provided any consideration. So if we compare that to the option contract at common law, you know that option contracts require consideration to be valid. The merchant's firm offer does not. All right. It does require that the offer be written and also signed by the merchant. All right. It doesn't require a duration. It doesn't require for how long. And the UCC imposes a reasonable amount of time. Now note that reasonable is going to differ depending on the subject matter. Right? So if we're talking about cars, in the example I just used, it may be a week or so. Right? If we're talking about commodities, crude oil, it may be longer than that. If we're talking about perishables, it may be just a few days. Right? So the reasonableness does come into play, but there is a hard line. Firm offers cannot be held open for longer than it's going to be 90 days. All right, so that's the upper limit. Okay. Acceptance under the UCC. So by and large, it doesn't modify the common law that much. The one nuance is that under the UCC, for sale of goods, acceptance need not be communicated, or I should say can be communicated by shipment of the goods requested. All right. And so in our example, Bill's convenience store sends an offer to purchase 2 cases of dish soap to Tom's wholesale. Tom responds with shipment of goods. All right, so Tom doesn't bother to pick up the phone, doesn't send an email, doesn't say these goods are on the way. Just 2 days later, 3 days later, what have you, UPS shows up with 2 cases of dish soap and an invoice. Well, in that case, Bill's Convenience is going to be obligated to pay for those because the UCC allows for acceptance by shipment of goods. All right. Now, it is worth noting, everything we're talking about is a default provision under the UCC, which means if Bill's doesn't want time to be able to accept by just shipping goods. They have to include that language in the offer. All right, and everything we're talking about in the UCC is a default provision, which means you can contract around it. But keep in mind, the objective of the UCC was to streamline business sales with kind of a standard set of rules. So contracting around it tends to undermine that and make it more difficult to do business with other business partners, other buyers and sellers who are used to the standard provisions. Additional terms. All right. So you may remember the common law mirror image rule. And that is that if you add an additional term with an acceptance, you haven't accepted. It's not an acceptance. It's a counteroffer. You know, the I accept if. At common law isn't an acceptance. It's a counteroffer. Well, we back off of that under the UCC. And we need to understand if we're dealing with merchants or consumers, because this is another example of a rule that differs depending upon who the parties are. All right. If you have two merchants, right, and this could be a manufacturer to a wholesaler to a retailer. If you have two merchants, and let me make that point once more. Manufacturers, wholesalers, and retailers are all going to be merchants, right? So if we see that in questions, understand that those parties are merchants, all right? If both parties are merchants, additional terms are part of the contract unless the other party objects. So this is sometimes called the battle of the forms. A lot of wholesalers, retailers, manufacturers have form documents that have clauses on them, and oftentimes those clauses will contradict, and that's why it's called the battle of the forms. But additional terms become part of the contractual agreement unless it materially changes the deal. All right, and there's some subjectivity there, but you know, if I'm selling groceries, if I'm selling produce, fruit, additional terms cannot also add in options, you know, or negotiable instruments, or anything that is not what the parties initially agreed to. All right. Cannot be a material alteration. Material alterations are going to be things that substantially affect the risk of the transaction for one of the parties. All right. Parties can also limit acceptance to the original terms. All right. So that can happen too, but if so, it needs to be done in the initial offer. All right. Or it could be done in the initial acceptance, because it can go both ways. All right. If one party is not a merchant, i.e. retailer to consumer or consumer to consumer, because keep in mind, if I sell my used car, the UCC, to another consumer, I'm not a merchant because I'm not an expert in cars, but the UCC would still apply because I'm selling a good. All right. If one party is not a merchant, additional terms are ignored. All right. So keep in mind, that's still not the common law mirror image rule. Right? Because the common law mirror image rule would be that additional terms mean we don't have a contract. I've made a counteroffer that the original offeror can either accept or reject. But if it's for the sale of goods and the additional terms are there and one party is not a merchant, they just have no legal effect. They're ignored. But we would still have a contract. Alright? You may recall at common law that if I, in a contract for services, if I call a landscaper and ask the landscaper to cut my grass, and the landscaper shows up and cuts my grass, and I also ask the landscaper to trim the bushes and do the edging. Well, at common law, for me to hold that as enforceable, I would have had to have offered an additional consideration. Under the UCC, modifications, even modifications that require more work, more effort on behalf of the seller, don't require additional consideration. I don't have to pay any more for it. All right? Statute of Frauds. All right, so you may recall the Statute of Frauds exceptions from 2080. These are contracts that have to be in writing to be enforceable. All right, and so the other categories were to surety or guarantee, cosign on the debt of another, contracts that take longer than a year and a day to perform, prenuptial agreements, and contracts involving interest in land. Those are your other statute of frauds exceptions. But the fifth statute of fraud exception is sale of goods in excess of $500. All right. Some states do change this number. All right. So this may vary from state to state, but in the Uniform Commercial Code, the committee included $500. All right. And so you need a writing. Must be signed by the party against whom enforcement is sought, but the signature requirement is pretty basic. It can be a name typed at the bottom of an email, or anything indicating agreement. That also, not agreement, intent to contract. All right. But there are a laundry list of exceptions to the statute of fraud. And these are equitable exceptions that are designed to prevent one party from being able to take advantage of another because of the lack of a writing. All right. And so those exceptions are specialty manufactured goods. Okay. So if I call Vistaprint and I have them create ink pens with my company's name and logo on it, and I order $600 worth of pens, and they show up, and I decide, I don't really feel like paying Vistaprint today. Well, and it was an oral contract anyway. I'm still going to be up the creek because, or I should say, I'm going to have to live up to my contractual agreement, even though it was an oral contract, because it was specially manufactured. The idea is that we don't want the seller of goods to be left holding a bag of goods that have no market, right? If they have my company name on them, it's going to be hard to sell those ink pens to the next company. It's going to be hard to get that company to change their name, right, to buy these ink pens. So specially manufactured goods are an exception. Admissions. So if in writing or verifiable conversation, I admit that there's a contract, then courts will enforce that. All right. Partial performance is also evidence, right? If I have, was delivering goods, and then I say, wait a minute, there's no contract here. Well, why was I delivering the goods if there wasn't an existing contract that's already been partially performed? So when you think about it, those are some pretty broad exceptions to the writing requirement, and they're really designed to prevent one party from an inequitable or unfair decision because of the lack of writing. Because it's really not uncommon for these types of transactions to not have a writing, or that the writing is not signed by the party against whom enforcement is sought. All right. And this is just a graphical representation. This is also in the book of your of what we just talked about, right? And I put it in here because I like the way this sums up our discussions. Okay.